So, good morning, everyone. It's a pleasure to coordinate this panel. And we are now privileged to hear the presentation from Felipe Jiménez, Professor Felipe Jiménez, who will speak about rights, interests, and tort as an instrument. Professor Felipe, you have 30 minutes, and then Professor Keating will provide comments about your ideas. And would you like me to inform about the remaining time?
No, I have a timer.
Okay, no problem.
Thank you. Well, thanks again, Diego and everyone for inviting me. It's really a great pleasure to be here. It was a really great opportunity for me to be able to talk about my book project yesterday, and I'm also very happy to be today talking about Greg's excellent book, Reasonableness and Risk. It is indeed a really great book. I mean, many people have already acknowledged the fact that it's a really significant intervention in tort theory. And I don't say this, or at least not exclusively, because Greg is a friend and a colleague, but it's really a marvelous book. And just to situate it a bit, like if you try to do like a short intellectual history of American tort theory, I would say there's like 4 significant books, and this is the 4th in that series. So I would think Coleman's Risks and Wrongs, Weinreib's The Idea of Private Law. The 3rd I would probably put together because of their temporal proximity, both Ripstein's Private Wrongs and Goldberg and Sipurki's Recognizing Wrongs. And I think the next one is Greg's Reasonableness and Risk. And I mentioned this because, not just because of the temporal sequence, but I think one great virtue of the book is that it's a very powerful synthesis of what's come before. That overcomes, I think, some of the limits of pre-existing tort theory. And it's a synthesis, I think, in a deeper sense, in a way that I think makes this book different from the other books I mentioned, which is, I think it takes the particular history of American tort law very seriously, in a way that I think those other books, despite their, indisputable merits, don't, because they're not concerned that much with giving an account of that is faithful to the history of American tort law. I think this book has as one of its many virtues the fact that it takes that history very seriously and tries to provide a cohesive theoretical account of that development. I mean, there's other ways in which it's a great work of intellectual synthesis, because it combines its historical outlook with a really deep, thoughtful articulation of contractualist political philosophy. It integrates too, I think, some of the insights of law and economics. So I don't think it's a coincidence that many legal economists are more sympathetic to this book than to the other books that I mentioned, because I think this book makes space for that type of view. And that's precisely what I want to talk about today in my comment. So the one thing that is distinctive about the book and that sets it apart from the economic tradition in tort theory is that the book really tries to take seriously and vindicate these very basic moral intuitions about fairness and interpersonal justice, as well as about the significance of harm within tort law. And in that sense, you could say the book is at a very different position from the law and economics tradition. But at the same time, the book, I think, is a very powerful rejection of the formalism of Kantian theories like Weinreib and Ripstein, and to a lesser extent of the thinner but still formalistic formalism of Goldberg and Sipurski. The basic move in this respect is to argue that the whole point of tort law is that it's an instrument for vindicating fundamental human interests. Okay, and so here in this comment, I want to explore this line of contrast with the Toronto formalists by focusing particularly on chapter 3 of Reasonableness and Risk. Okay, so Greg makes two central points in chapter 3 of the book. The first is that rights protect interests. So one cannot understand or make rational sense of the rights protected by the institution of tort law unless one can ground them in some urgent human interest that the institution is trying to protect. And from this first point follows the second one, which is that tort law is just one of the many legal institutions, both public and private, that protect these urgent human interests. And in this very narrow sense, at least, Keating is an instrumentalist. He thinks of legal institutions as tools that are part of this larger toolbox that societies have to try to protect and vindicate these human interests. So it's one phrase that Greg uses to capture this idea is to think of tort law as one institution situated within a larger web of institutions, okay, some of which are part of what we would ordinarily call private law, some of which are part of what we would ordinarily call public law. And in this respect, I think Greg is at odds with the formalism of Kantians. So for Arthur Ripstein, for example, the notion that grounds the rights recognized and enforced by tort law is the simple idea of mutual independence, the idea that no person is in charge of any other. Interests, on Keating's view, on Ripstein's view, play no independent role in grounding rights. Of course, Ripstein, like Weinrib, would accept that tort law realizes values and protects valuable human interests, but they would say that these functions that tort law might perform are not the reason why tort law exists, or the explanation for the particular rights it recognizes. So in terms of the current fashion metaphysics, they would say that these interests are not the grounds of tort law. They're not the fundamental constitutive explanation that explains, in this kind of radical sense, why tort law exists. On the contrary, they would say the rights of tort law are merely the rights that derive from this idea of abstract right or mutual independence. Greg, I think, has very plausible worries about whether this type of view can make sense as an interpretive matter of the common law of torts, particularly in its American incarnation. But he also has deeper philosophical worries. For Ripstein, the law of torts concerns itself with the particular interaction between tortfeasor and victim. Its role is determining the conditions under which purposive beings can coexist with each other as mutually independent. This means that for Ripstein, like for Weinrib, there's a strong division of labor between private law institutions, like tort law, which realize this idea of mutual independence, and public law regimes focused on questions of distributive or background justice. In response, Greg argues that tort law and the institutional domains of distributive justice have complementary roles. Tort law is concerned with harmful interpersonal violations of rights, which are explained by distributive justice. So distributive justice and tort law are part of the same game. One articulates what the rights are, the other is trying to vindicate them in interpersonal interactions. So there is a distinction between the domain of tort law and the domain of basic distributive justice, but the distinction is not premised on a strong idea that tort law is concerned with mutual independence or abstract right. The distinction is merely that tort law deals with a particular upshot of the rights determined by distributive justice, namely, and to use Greg's own phrase, what those rights require in the way of coercively enforceable reciprocal obligations. So what those rights are in the first place turns on which urgent human interest the law ought to recognize on the basis of, among others, considerations of social justice writ large. So in Greg's view, legal rights specify and determine the interpersonal demands that arise from these specific fundamental human interests. They are institutional instruments in the service of these interests. The upshot is that understanding tort law requires understanding which interest the body of law picks out for protection, and presumably, morally evaluating and justifying tort law would require a moral view about which interests we ought to be picking out through this legal institution. Once we engage in that exercise, we can see that only some torts, paradigmatically what Greg calls sovereignty-based torts, are directly concerned with an idea like what Ripstein calls mutual independence. For a lot of what tort law is concerned with, though, we need to appeal to interests. In this respect, I find a lot to agree with Greg. I think it offers, in fact, a more compelling conception of tort law than the very thin conception articulated by Kantian formalists. But in this comment, I want to press Greg's view in two directions. First, I want to further explore the relationship between moral interests, moral rights, and legal rights. And second, I want to suggest that the thought that legal institutions, like the law of torts, are instruments, which I think is correct, can have more radical implications than those that I think Greg would want to accept. Let me start with the idea of the relationship between interests, moral rights, and legal rights. So in an important section of his argument, Greg writes that, on his view, three facts obtain. First, a claim of moral right asserts that some interest is important enough to warrant legal protection. Second, legal recognition of a right imposes constraints on others in service of that interest. And third, the protection that legal rights confer on interest creates some gap between the interest and the right. So we start with this idea of basic moral interests. Those basic moral interests give us a moral reason to confer certain forms of legal protection through the law of torts. Then that form of legal protection imposes certain constraints on the legally admissible behavior of other agents. But because we are choosing to protect this interest through legal rights, there's always some potential gap between these original interest that's at the beginning of the story and the institutional realization of that interest in the particular way in which tort law enforces the legal right. But regarding this third point, Greg argues that we should not make too much of this potential gap between legal rights and the underlying interest. There is usually, though not always, a harmonious relationship between rights and interest. When there is no harmony and we feel this conflicting pool of legal rights and the underlying interest they serve, basically in what Dworkin would call a hard case, Greg says, and here I'm quoting him, reasons rooted in the interest that justify legal rights guide the application and articulation of the rights that they justify. I largely agree with this view, but I think that the third idea that Greg mentions, the idea that there's a gap, but it's small, is a bit more troublesome than what Greg gives it credit for. The structure that goes from the basic interest that, on Greg's view, ground the whole institution of tort law to the decision of particular tort disputes goes basically from interests to claims of moral right to institutionalized legal rights to particular decisions in particular cases. And I think the first transition from interest to claims of moral right, so basically to moral demands about the recognition of this interest through institutional mechanisms, that first transition, as I say, is relatively simple, at least in the sense that we can have moral uncertainty and moral disagreements over which interests qualify for protection. But once we know, or once we agree at least on a provisional answer to that question, then the relevant moral claim flows relatively naturally from the moral argument, right? So if we think we have a very basic interest in physical integrity, then I think the claim that there's a powerful moral argument for that basic interest to be recognized in legal institutions is relatively easy to make. But the two later transitions, first from this moral claim to a particular institutionalization in a legal right, and then from legal rights to particular case outcomes, becomes a bit more complicated. So take first the transition from moral to legal rights. Even if ultimately grounded in moral rights and in the interest they recognize, in a more immediate sense, the content, structure, and scope of legal rights is determined, at least in part, by legal materials. There are two potential problems that arise here. First, the relevant decision makers, legislators, and judges, most obviously, might not structure the legal right adequately. The legal rights recognized by our legal institutions might only imperfectly track the underlying moral right. Now, of course, here, it's an open question to what extent our lawmakers, and particularly judges in the common law tradition, might be making mistakes or might not be perfectly capturing the moral right. But second, there's a more important concern, which is the adequate design of these legal materials is supposed to take into account a host of considerations beyond the recognized moral interest. To name a few obvious considerations, reasons pertaining to the effective guidance of conduct, reasons pertaining to sociological and psychological facts about the agents whose conduct we are trying to guide, reasons that have to do with the epistemic, institutional, and economic constraints faced by judges supposed to enforce the relevant legal rights, reasons about spillover effects regarding other legal regime. In the case of American tort law, facts about juries and how juries make decisions, etc. All of these considerations play a role in how we think about the relevant legal rights and might therefore drive an important wedge between the legal right and the underlying moral interest. And I think where it gets even more troublesome is when we think about the transition from the legal rights structured generally in the legal tradition, in a statute, in a line of cases, to specific case outcomes. Legal rights are set up generally by general legal norms derived from cases, or more typically lines of cases and statutes. Now, in contemporary legal systems, rules do not really behave according to what Rawls called the practice conception. They are not followed in every single instance, even when the results are thought to be suboptimal. So legal rules are, in most legal systems, divisible, right? So in a common law systems, for instance, we have practices like overruling or like distinguishing, which I think are recognitions of this fact, of the fact that sometimes a line of cases might generate a particular outcome that might be problematic, and in those situations, I think judges have the tools to try to wiggle their way out of these dilemmas. But crucially, I think legal rules, even in a common law system, also don't behave according to the summary conception articulated by Rawls. They are not merely rules of thumb that summarize the underlying values or goals they aim to achieve, or to put it in Greg's terms, the moral interest that they're trying to recognize. Instead, rules are resilient and treated as decision criteria, even when they are sometimes over or under inclusive. So legal rights sometimes lead to case outcomes that are, from the perspective of the underlying interest, suboptimal. I don't think this is necessarily morally problematic. The relevant moral question to ask about legal institutions, in my view, is not whether they perfectly replicate an ideal moral template in every single case, but whether, as institutions, they produce in the aggregate a good set of moral results. So in the terms of Greg's theory about tort law, the question is whether the law of torts, in the aggregate, does a reasonably good job at protecting fundamental human interests, even if, given the way in which it's structured through general prospective legal rules, it might in many cases not do so. But that means too that the connection between the underlying interests and values and the content and structure of tort law will not be necessarily neat and tidy. And here I think we can come back to Kantian formalists like Ripstein, Weinrib, and Martin Stone, who actually, in a comment he wrote about the book, presses Greg precisely in this direction. On the Kantian view, legal rights and judicial decisions are determinations of a more abstract idea of right. So in Ripstein's terms, it would be a determination of the idea of mutual independence. That suggests two things. First, because the point of legal institutions and legal rights is not to act as instruments of any underlying moral aims or values, questions of instrumental legal design, basically about which legal design will promote the best outcome, like the ones I mentioned in the previous section, are at most of secondary importance. And second, because legal institutions determine and specify an abstract demand of right, there is in fact a lot of leeway for them to do so in different ways. There's no determined extra-legal ideal that laws ought to approximate as much as possible. Greg, on the other hand, I don't think can make use of similar strategies in order to deflate some of the worries raised by the potential divergence between case outcomes, legal rights, and the moral interests they serve. For he is indeed an instrumentalist about legal institutions. And this means that questions of optimal legal design, about what is the optimal system of rules and institutions that in the aggregate produces the best outcomes, in his terms, that in the aggregate best serve the underlying moral interests, ought to loom large. In my view, this is in fact the strength of Greg's theory, but it has two implications. The first is that there might be a morally legitimate, as in instrumentally justified gap, that might be quite large between the legitimate structure and content of tort law in a particular society and the very abstract underlying moral interest and rights it is serving. This introduces a possibility for a certain opacity in legal reasoning that I think Greg, who is to some extent a romantic admirer of the common law of torts, might not be that willing to take on board. And the second is that the work of social scientists, and particularly of economists, becomes fundamental for a project like Greg's. Indeed, whatever its demerits and defects as a normative theory about private law's foundations, which I think it has many, the economic analysis of tort law is the most complete, thorough, and rigorous tool we have for evaluating the impact of legal rules, legal institutions, and legal decisions on human behavior. We don't have any other framework that is as developed as the economic theory as a way to predict what consequences legal rules are going to produce. And this, I think, suggests that Greg's tort theory and law and economics might be closer companions than what first impressions might suggest. So one way to think about this is, at the level of normative theory, Greg and legal economists are completely at odds from each other, right? Greg is a non-welfarist theorist. He thinks that there are fundamental human interests that matter not because they are valued by agents, not because they coincide with their preferences, not because they maximize welfare, but because they're actually constitutive components of human life, or a decent human life, under his own conception of political morality. But there's another sense in which I think actually Greg is opening up a great invitation for legal economists. He's basically saying, because legal institutions are institutions that ought to serve instrumentally these underlying human interests, then there are all these empirical questions and questions about optimal legal design generated by his own framework. And I think that's why it's not a coincidence that many legal economists are much more sympathetic to Greg's own view than to Goldberg and Szypursky's theory or Weinreib's theory. Even though they have very different moral views, presumably, I think at least legal economists can see that, here's a theory where all of the things that I have learned, all of the tools that I master, can actually play a very important role. Now, there is a response, and I don't want to anticipate Greg's response too much, but I think Greg or someone else who might want to vindicate Greg as a less instrumentalist theories that I'm suggesting might want to offer here. I might be making too much of the idea of legal rights and institutions as instruments. While Greg does think of tort law as an institutional instrument, he still thinks that the rights structured by the institution simply put flesh on the bones of the interest that they serve by specifying legal constraints on other people's behavior. And if that is the case, then the design of tort law's rights and the actual deliberation about how to decide particular cases by judges and juries should transparently engage questions about the underlying interests. So think, for instance, about the right to privacy. The link between rights and the underlying interests is, on Greg's view, much tighter than I've suggested. So tight that usually the name we give to the right is connected to the interest they serve. So in the case of the right to privacy, the right is named after the interest we have in privacy, right? And so on this view, Greg's instrumentalism is in fact compatible with the claim that the reasoning of common law courts and juries ought to track as much as possible the underlying moral claim. The issue here, though, is that if you are an instrumentalist, it is an open empirical question whether a transparent form of legal reasoning will in fact be the best way to make sure we best protect the underlying moral interests. The facts in any particular legal system at any given point in time might be such that in reality, the best way to make sure that courts and juries protect the underlying moral interests is by not engaging questions about them directly. So to mention a kind of a familiar consideration, if we know that judges are going to make systematic mistakes in a certain direction by directly appealing to moral interests, the rational way to structure the legal system might be to tell judges not to consider the moral interests, because we know that if we do that, that might be self-defeating, and therefore will mean that the institution of tort law will be worse at serving the underlying moral interest. There is a long tradition of these arguments that goes back to the distinction between rule and act consequentialism, but is visible in contemporary contract theory. I think there are theories that have tried to explain a kind of compatibilist position in tort theory precisely by trying to exploit this issue. But the crucial point is the following, and here I'm going to finish. Once one sees a legal institution as an instrument, it doesn't matter what values the instrument is serving. The instruments can be as deontological as we want them to be, as non-welfarist as we want them to be. But as long as we think of a legal institution as an instrument, it's always an open question. What is the right approach for legal institutions to take, for judges to take, and what is the right design for legal institutions? It all turns out on the facts, on the empirical evidence. From this perspective, I think it would be a very happy coincidence if pursuing the vindication of moral interest directly in transparent, morally compelling, open common law adjudication in the style that Greg actually admires were the best way to vindicate this interest across the board. And I think Greg, in fact, is ultimately committed to precisely that view, given his obvious commitment to the idea that different legal regimes, tort law or some other public law regimes, might be adequate in different contexts. In this regard, I think his account is significantly superior to the Kantian insistence on treating legal institutions as non-instrumental. But again, I think it puts a bit of pressure on Greg's own views about how functional, how adequate the method of transparent common law reasoning evinced by some of his heroes like Traynor and Cardoso would be at serving this interest. Again, if you're an instrumentalist about tort law serving this interest, I think it's always an empirical question, subject to contingency, whether a method like the common law reasoning that American courts use is actually the best way to achieve the goals that Greg says the institution is trying to serve. Okay, so I'll stop there.
Thank you very much, Felipe. That's a characteristically perceptive, thoughtful. I'm very lucky to have Felipe as a colleague and a commentator. So I agree with probably almost all of that. Let me see if I can get at an area where we might disagree a little indirectly in the spirit of, since part of what you're pointing out is that sometimes it's best to pursue things indirectly, not directly, which is also a paradoxical implication of the Rawls paper you like so much. So first, let me try first cut with the privacy. Privacy is a really interesting example here because the tort just takes its name from the interest that it protects, and I think it has a very interesting history in American legal thought and law because it is traceable sometimes to an academic article written by Brandeis and someone else named Warren, and Brandeis went on to become a Supreme Court justice and is a very, very big figure in the history of American law, called The Right to Privacy. And the basic argument of that article is to take a bunch of cases that present themselves as property cases and say, these aren't really property cases, because really they're vindicating a different interest from the interest that property law interests, which are about external objects and owning them, using them, disposing of them. Now I'm going to add a little bit to the article, but the interest in privacy is different. It's the interest in being free from unwelcome observation. And that article is generally thought to have had enormous influence on the restatement, recognition of privacy torts, and on the development of the law itself. And so in that sense, there's this really tight connection. But there's also a sense in which I think the privacy torts show how problems of institutional design can loom very large. And here's why. Privacy is a social condition. It's being free from unwelcome observation. And so if you consult like philosophical literature, you might be offended if you're in the library and reading and somebody decides that they want to paint your hand. I didn't give you permission to paint my hand. I have no particular idea as to whether anybody has a reaction one way or another to this, but it's an example. But the fact is, privacy is a sort of social phenomenon. There have to be socially constructed spheres where you're free from unwelcome observations. So like, want someone painting your hand, read in your own backyard, don't read in the public library. And that seems to be an unavoidable fact about privacy, but it also in some ways is out of sync with what you might think is the first best articulation of the interest, which is, Felipe referred to sovereignty torts. An example of a sovereignty tort is battery in some incarnations, trespass in some incarnations. Really, trespass is the best example. It's, you can't come onto my property without my permission. I'm sovereign here. Sole and despotic dominion was Blackstone's expression, and I exercise my will to decide who can and cannot come here. Well, you might think the best articulation of privacy would be a sovereignty tort, which is I get to determine what kind of observations are unwelcome and what are okay, and I control the observations upon me accordingly, because people probably have very different tastes as to what's objectionable observation and what isn't, and to protect that interest, which can fit into an account of, Warren and Brandeis had a romantic count of human personality, a kind of liberal, flourishing view. People should be able to define the domains in ways that are best for their flourishing. Is infeasible, because privacy is a social condition, so you can't create a power out of it. So the torts, and increasingly I think in the world in which we live in, you don't get privacy, you get anonymity, like every single credit card transaction. Your bank is surveying if they care, wait for lunch or whatever. But you mostly think, they don't care about me. I get anonymity, I don't get privacy. That I think is an example of where you can't really figure out an institutional design that would in the first best way realize the interest that's underneath it. Now, a second thing is, so what sort of stance should I take on that? I think what I sort of need as a minimum claim is, well, in my view, when you start thinking about these questions, you want to put the interest in the center of your deliberative field. There are other considerations that cannot be ignored. But if those other considerations come to dominate the interest that you think is fundamental in thinking about the institution in a systematic way, I think the right has to be in a systematic way, you're in the wrong place. And I hope that's feasible. That is, you might discover you can only imperfectly protect the interest. And some interests you can discover you can't protect effectively at all, or one that, along with privacy, the American tort law has been struggling with for a century, and I think it's made real progress, but it's hardly perfect, is emotional harm. I mean, figuring out what counts as emotional harm and whether we are actually per se interested in the experience of distress or emotional harm as a marker for another kind of harm. So the most famous American case expanding liability for negligent infliction of emotional distress involves a mother who witnesses her daughter being killed by a negligent driver. And you might think that the distress there is the marker for this relational harm, a harm that is to the mother because of the amount of that she's invested as a human being in her child, such that the death is an impairment of her life, and that the distress is just a marker for that. So there's hard issues there. But courts have just come to the conclusion there is more emotional harm that people would like to be protected against than we can feasibly protect people against. And that's unfortunate. I don't think it's bad for my way of thinking about it, as long as we can think about that in terms of what's the fundamental interest here and can we vindicate it. There is also, I should plead guilty to being romantic about the common law. It might be a tendency of American, and we're much more romantic than the English, I think. I think when I was coming up, there was a legal theorist Ronald Dworkin, still very important legal theorist, just not alive. And if anybody had a romantic view of the common law, Dworkin did, and his judge was named Hercules because Hercules could basically reinvent the legal universe in the course of deciding a single case. And even if you think, well, that can't quite be right, he exerted more influence. He was clearly the preeminent American legal academic of the, I don't know, 1965 to 2000 or something. And he exerted enormous influence over a lot of us, and you think, boy, that would be a wonderful thing if you could realize it. I do think to some extent the common law can realize that, and in England as well as the United States, I think the discussion we're having about how you can, in fact, reconfigure the law of negligence to address institutional responsibilities that, for whatever reason, previously we didn't think should even be within the zone of the legal, which is really what is going on with the abuse and harassment cases. Those things did not exist before 1990. They just didn't really enter the domain of things where we thought we were going to impose legal responsibilities. And I think the common law might have advantages over statutes in this respect, because I think statutes have big advantages in just articulating coordinate responsibilities and systematic responsibilities, but they produce rules that come much closer to the practice conception. Common law rules do have the virtue of not being identified with a canonical verbal formulation, and that allows Cardozoan judging and the things Dworkin describes, which do exist. So I'll plead guilty, but with an excuse on the romantic thing. Still the best option. And then I guess I wanted to say, I think I'm just amplifying on the Kantian view. I think Felipe gave a great characterization of it, and I think that's right, but I think you can either call it puzzling or inadequate, and the question is how to illustrate that. So on the Kantian view, there's a sense in which, because what you're doing is this purely relational thing, you're just articulating the relations of non-domination between persons. You would think often when you talk about non-domination, you might need to talk about interests, and I do think that. But they think you just have to articulate legal rules such that I'm in charge of myself and no one else is in charge of me, is really the way Rupstein puts it, which is very helpful. But I think in terms of torts, only describes some batteries and some trespasses. In fact, you can't argue in the book really account for negligence that way. But also, you have a peculiar view. One of the features of it is where you can't really criticize the view as doing inadequately what it's out to do because it's so purely constitutive. In other words, if you articulate the tort norms and say, these are the norms, there's a whole bunch of ways you could do it, and when you've done it constitutively, apparently there's no further criticism. That just doesn't seem to be line up with sort of basic legal phenomenon. So to take one is the rise of product liability law in the United States as it's generally understood. Not perfect history in terms of what revisionists have turned up, but the rule of privity of contract. The rule of privity of contract basically enables manufacturers to free themselves of responsibilities to end users unless they're also purchasers. And I don't know if there's anything formally wrong with that within the framework of something like Ripstein or Weinrib's or formulation of not being in charge of yourself and not in charge of you. But it's profoundly inadequate in the sense that you can be at the mercy of the great power that manufacturers have to actually construct the terms of legal regimes because they are systematic and organized and can get you to sign waivers and disorganize. And here's where economics tells you a lot. Consumers have massive organizational problems, critical mass problems, and information problems. And so you can have a formally unobjectionable legal regime that's substantively inadequate to protecting people's independence even. I think it doesn't protect independence, even if we don't go to my emphasis on harm. And I think a reason for that is there's a mistake in the Kantian position, which I would put as, I think even agents have interests. And if one were to trace this further back into philosophy, I used to think I was pretty Kantian until I encountered the Canadian Kantians, and then I thought, I guess I'm Millian, but maybe I am. But the reason I thought I was is because in the United States, Rawls, preeminently, but others too, domesticated Kant in a certain way. They are not full Kantians, but they're not full, by any means, utilitarians. And what Rawls, one of the domestications was to say, there's interests folded into Kant, he just doesn't talk about them. Like, therefore you need a theory of something like primary goods, which are goods that anybody needs, no matter what else they need, and he's got wealth, income, social basis of self-respect. Well, from my point of view, you can think of safety that way, or avoiding harm in that way. And I think unless you're going to be full noumenal being, which is disembodied, then you have those interests as an agent. And so that the rendering of Kant by the people who appropriated him is the most austere rendering, and in some ways an unfortunate rendering. So I wouldn't give quite as much ground up as they think I have to give up, even though I am in important ways instrumental about legal institutions, because I don't think a non-instrumental position, as non-instrumental as they claim to be, is ultimately plausible. It's elegant, but it's implausible. And it sort of, in that vein, on instrumentalism and constitutive, I think my view of institutions is instrumental in the way you say, and that's because you don't want to endow institutions themselves with intrinsic value. You want to endow the human beings that they're supposed to serve and protect with the intrinsic value. But institutions can be very constitutive because they enable various kinds of interactions or forms of protection that just aren't possible without the institution. And so if you think of even simple things like how does the tort law use the traffic code? Well, without the traffic code, before that it tried to use custom and it could up to a point, you simply can't define coordinate responsibilities adequately. It's not something that can be done in judicial decisions or by conscientious individuals. So things like the use of what are really parts of public law, as the Toronto Kantians would think of it, actually enable tort law to constitute new kinds of safe relations among persons. And I think you should call that constitutive, not just instrumental. I doubt you disagree. And so I think you can get some of that, but in the end, I think it is true that there's nothing that will guarantee that my view will get the interest articulated correctly if you have the wrong judges and the wrong legislatures and the wrong understandings. And there will be maybe more of a gap because of the way institutional articulation can draw distance from the interests that originally justify it. And thank you very much.